The draft minutes are available. If members are content they're accurate, then I will send them accordingly. Agreed.
In a way.
Thank you.
And the first item is the fines and enforcement bill. So if officials want to step forward. The papers, members, are pages 13 to 95 of your meeting folder. Let me welcome Gareth Johnson, Deputy Director of Criminal Justice Policy and Legislation Division, Pamela Reid, and Tom Hare, all from the Department of Justice. And as usual, it will be recorded by Hansard and published in due course. So, Gareth, if I can hand over to you at this stage to take us through the paper.
Thank you, Chairman. And I should explain in terms of those of us at this end of the table, Tom Hare is responsible for the policy and legislation on fine enforcement, while Pamela Reid is currently responsible for the operational development of our fine collection services. The paper we've provided covers two topics: the content of the proposed fines and enforcement bill as a whole, and a consultation paper that the Minister proposes to issue to further develop our legislative proposals. And if the committee is content, I'll begin with that consultation paper and then return to the wider bill just in a moment. The last time we were in front of the Committee on Fine Enforcement Services was in February 2012, and we'd consulted on the concept of a new specialist fine enforcement service with additional powers. There was a particular focus at the committee on the safeguards which would go with those powers, and we'd given some additional commitments. So after that discussion, we went off to develop legislation. We got executive approval to start drafting it, and we launched a programme aimed at delivering the new service. Then, early last year, 2013, we had the judicial review of the fine enforcement arrangements which had been operating in magistrates' courts and in the wider justice system in Northern Ireland really for decades. The Divisional Court found that those arrangements were lacking and that default hearings needed to be part of the process before someone could be committed to custody for non-payment. It wasn't, though, clear that the district judges had the power to convene those default hearings, and the committee will be aware that we both brought our own judicial review to clarify matters, and in case that didn't succeed, we had prepared urgent legislation. In the event, the judicial review gave us the clarification that we needed. But all of that meant that we had to go back and look at our policy for the future in light of the judicial review and proof it against what the Divisional Court had said was acceptable. So if we seem to have been at this on fine enforcement for rather a long time, I do agree, but there has been quite a lot happening in the meantime. We are now on track with a programme to deliver a new fine collection and enforcement service. Part of that involves a fines and enforcement bill to which we've referred in written briefings to the committee on the legislative programme. The package on the fine collection and enforcement service really includes three things. First, a civilian-based approach to fine collection, which would largely remove the police from all but the most obstinate cases. Secondly, it involves providing powers to deduct money when agreements with a defaulter about instalments and additional time haven't worked and where prison might otherwise be imminent. And thirdly, the package would allow the community-based supervised activity order, which we've piloted, to be more readily available. Broadly speaking, the package is, of course, about preventing default, and it is very much about reducing the numbers of people going to prison for fine default through supportive means. At the same time, the aim has been to free up police officer time for more frontline duties and to increase the availability of police officer time for hard pressed areas rather than areas like fine default, which can be dealt with in other ways. Now, all of this builds on the experience of the reminder system, which the Northern Ireland Courts and Tribunals Service has been operating since May 2009. That has resulted in 28% more defaulters making payment, and in total the service has ensured that £5.9 million has reached the public purse. We also developed a default register to alert the courts to outstanding fines. Now, the Minister has taken the approach, and it's important that I should emphasise this, that as we move forward, the streaming of fine defaulters is important. Across the water, they call it intelligent enforcement. There are those who find they have difficulty in paying a fine, genuine difficulty, and the emphasis for them would be on a supportive model, and we have experience of that from the Fine Reminder Service. Fines officers could provide additional time to pay or allow payment by instalments. If that didn't work, they could then move to compulsory deductions from earnings or within tightly controlled limits from benefits, the object being to keep someone out of prison. Working with colleagues such as Pamela on the practicalities of delivery and the type of fine collection service that could be created has raised some thoughts with us on additional provisions that would be useful to have within the armoury of a new service, and that's why the consultation paper is before the committee today. I mentioned streaming or intelligent enforcement. One stream is the people who have difficulty paying, but we can work with them on a solution to that, even if it takes some time before the whole fine is paid off. But there is another stream, which is of people, often multiple offenders, who belligerently refuse to pay. And visits to other jurisdictions have shown the importance of deterrence as an added incentive in those kind of cases to clear a fine. So it's important that this service provides both for support and for deterrence, so that the service can adapt and streamline its response according to the individuals before it. And so the department, particularly with that deterrence theme in mind, is keen to take views on 4 further options that could be brought into the bill. And the first is a power to seize vehicles. Now, Scottish colleagues have spoken very highly of the deterrent value of this power. And even if it's only deployed very occasionally in particular circumstances, it has allowed officers to use it as an incentive to encourage payment. As you'll have seen from our paper, many of those are fined for motoring offences, so it does have a kind of link to where a big body of fines rests. As a power, the seizure of vehicles is already available locally for driving without insurance or for driving a nuisance vehicle, so it's not without precedent. But a code of practice would be needed to ensure that it was only used in serious cases. We are not looking at seizing the car that a single mum who has been fined for not paying a TV licence is using to take the children to school. And the code of practice is the way of ensuring that the service takes such a streamed approach. The Mercedes that is being driven by the persistent offender might be in a very different category. Similarly with the second power proposed, which is one of direct access to bank accounts. Again, the Scots have this power and they have used it where someone has assets but is simply not paying a fine. It's worth noting that within Northern Ireland this is an option that is already available in terms of debt recovery. The other 2 proposals then relate to the use of community disposals or imprisonment if default does occur in the end. And I would want to stress in the end, because this package with a new service, with specialist officers, with new powers, is aimed at doing as much as is possible to prevent people getting to a point where the likes of custody needs to be considered. But of these two other proposals, the first relates to the supervised activity order, and that is that anyone with a fine of a certain level, perhaps up to £500, once the service had tried all of the routes that I've just mentioned, that offender would normally get a supervised activity order rather than imprisonment, and it would only be if the supervised activity order failed that they would potentially go to prison. Prison, as we've acknowledged on a number of occasions before, is really not a satisfactory way of dealing with fine defaulters for reasons that are familiar to the committee, and the supervised activity order is something we want to encourage as giving back to the community. The second and final then of these proposals relates to prison remission. Fine default is not a public protection issue, so it's not within the ambit of the public protection sentences of the 2008 order, which removed remission from many sentences. So remission is still available, 50% remission is still available on a fine default period, and our paper shows the effect that that can have. Some would say that that adds to the incentive for some people consciously not to pay their fine. If you are crafty about it and if you turn up at Maghaberry at the right time, you can end up spending a very short period of time in prison. So might the removal of remission, the removal of that 50% remission, encourage more to pay when faced with the prospect of spending longer in prison? Might the ultimate backstop of custody be a more meaningful threat in those circumstances, and encourage people to deal with their default at the earlier stages, including through the supervised activity order? And that's something on which the department wants to take views through the consultation exercise. We are considering, as I say, these 4 additional developments. We seek the committee views and through the consultation, the wider public's views on them. As I've emphasised, at a practical level, a collection officer would only be considering them in particular cases, guided by a code of practice, and in specific circumstances, particularly with multiple offenders or those who are in effect giving 2 fingers to the system by not paying fines. Chairman, I thought it worth then just closing with the plans for the bill more generally. This is what I've been describing as perhaps the biggest part of the bill, but there are other important areas that we want to include in it. We're getting those ready for drafting in terms of the areas that we know we already have executive approval for. The committee will, I think, recall the Minister's letter advising of the plans to split what was then the Faster, Fairer Justice Bill in 2. That bill was becoming so large that it really, splitting it really was inevitable to allow proper scrutiny and delivery. A large part was already drafted, and the fines legislation, as I've explained, needed more detailed development. So in terms of the legislative programme as a whole, the human trafficking bill has been a priority for the committee and for the department, and obviously is currently before the committee. We are now bringing forward our short legal aid and coroner's bill, which we hope to introduce to the Assembly next month. That will be followed by the Faster, Fairer Justice Bill. Now, with judicious management and working with the committee, our aim is to ensure that the committee evidence periods for these bills don't overlap, though I understand there is the potential for one bill to be out to committee consultation while another is subject to evidence sessions. Our aim then would be to introduce the Fines and Enforcement Bill next October, and for the bill to complete its Assembly passage by the summer of 2015. So that timetable gives us the opportunity now to consult on these additional proposals around fines collection and to return to you on the results of that consultation before the summer recess. As I've said, the bill contains a number of other important changes that the department plans to make. One is delivering on our commitment for additional protections in the area of extreme pornography. Another is around the changes to youth justice law, which would underpin the move to accommodate under-18s in the Juvenile Justice Centre. There are improvements which have been referred to in the paper to the prison ombudsman and to the police ombudsman's positions. There are some changes to police powers, and there is the creation of an early removal scheme for prisoners who are liable to deportation. Now, those of us who are in front of you, while we're responsible for overall management of the bill, are not necessarily policy leads for all of those areas, but a number of those proposals will be returning to the committee before they're finalised for the bill, and the proper policy leads will be briefing. But in closing, if I could just say in terms of fine enforcement, that the Minister's main message and concern is to ensure that where a person is given a fine, they will pay it. That can be delivered in a range of ways, properly controlled and tailored, importantly, to fit individual circumstances. That's what we are all seeking out to achieve. Chairman, would be very happy to answer any questions.
Thank you very much, Gareth. And I'm not going to prolong the session because I'm content, obviously, at this stage for it to be consulted on, and we'll obviously have the detailed scrutiny at that point. So we will get into more aspects of it. Just a couple of quick points from me. That in terms of the prioritising community-based options instead of imprisonment, and you talked about custody still being a fallback. Obviously, for non-payment of a TV licence and things like that, I think that's entirely understandable in terms of a community-based type scheme. But there will be some fines that could be very significant that people receive, and ultimately custody as well may be that option. So just talk me through how that will work in terms of community-based approach while still retaining a custody element, and could that undermine a community-based approach if people can still ultimately resort to custody as an option?
Yeah. The aim of the community-based approach is really to deal with the very large number of lower fines. There is a limit in legislation, and Tom, I'm sure, will remind me, £500, that beyond that a supervised activity order wouldn't be available. But the vast majority of fines that we're talking about are in that category. What we're trying to do is to reduce the use of prison as far as possible. So we're suggesting that normally when someone gets to that point, and the new fine service would have tried everything else in the run-up to that, but they get to that point, the normal thing that a court would give would be a supervised activity order. The number of hours that order would cover is specified in legislation. Then it would be if that supervised activity order is breached and can't be completed, that the breach of the SAO would result in the custody. But for someone who, say, has a fine of £10,000 and had resolutely refused to pay, and we couldn't get at money or seize vehicles, then they would go directly to custody at that level of seriousness. And in fact, at that level, the custody periods are quite elongated.
In terms of the extreme pornography, is that to cover internet-based pornography, or what's the reach? I know this is in line with what was stated at Westminster. What is the areas that this will include?
It would cover any sort of pornography, whether it was yes, online and offline, whether it was on the internet, whether it was printed, whether it was on video. There is already provision on extreme pornography, which, for example, depicts necrophilia, bestiality, or violence that's life-threatening. And the aim of this provision is to bring depictions of rape into that classification.
Right, Mr. Lynch.
Thank you, Chair. You mentioned, Gareth, about instalments coming out of benefits being finely controlled. Could you elaborate on that slightly?
What we'd be aiming to do would be to fit the recovery of fines money into the existing regime for deductions from benefits. So at the moment, for example, family maintenance money, child maintenance money can be deducted from benefits. There are other examples too. There are a couple of restrictions on that. One is that there would be a restriction on the amount that could be deducted from benefits in respect of the fine. The other is that there would be an overall restriction on how much in total can be deducted from benefits across that and other categories, so that the person is left with an amount that's judged suitable for living on. What the deduction, even if it's a small amount a week, what it does do is keep someone out of default and keep them out of the threat of prison, and that's really what we're aiming to do through those deductions from benefits. They wouldn't kick in at the start. At the start, the fines officer would be looking to see what voluntary arrangement could be made, but that power is available.
Would you, sorry, Chair, would you be talking about a percentage coming out and a percentage staying, or what percentage would you be indicate?
There are two ways of doing it that I think we have settled on. Either one could be a percentage or one could be a minimum amount, but we would have to look at both.
Ms McCorley.
In the paper, there's mention of, in relation to fine defaults, those site visits to the south of Ireland and England and Scotland. Can you tell me what sort of experience emerged from that?
It was useful to see just what had worked and what hadn't worked in other jurisdictions. The colleagues were on some visits, and in addition we had a workshop here where people from England, Scotland and from Ireland came together to talk about their experiences. Some of the pointers were around the tools that were useful where you had people who were resolutely refusing to pay. That was where we were being briefed on the value of some of these powers, like vehicle seizure, like deduction, like direct deduction from bank accounts. Not things that you would use very frequently, but sometimes if you were seen to use these, or if they were something that a fine service could remind people they have the power to do, it might encourage payment in appropriate cases. There were also things that had been tried in other jurisdictions that hadn't worked. I mean, one thing we had been thinking about at one stage was whether if you paid a fine within 14 days or 28 days, you could get a discount on it. They piloted that in England. What they found was that the people who were going to pay anyway paid within that period and got the discount, but it didn't actually encourage other people to pay. So we were able to learn from that experience.
Okay. Can I just ask something about the supervised activity orders? What actual activities are involved?
In terms of what was done in the pilot, I think there were some people who were working in charity shops. There were some people who were involved in kind of caretaking duties and maintenance duties. Yes. We would be working with the probation service to come up with a suitable range of activities. I mean, it might be for some types of offender that you wanted to provide activities which were reasonably challenging. It might be that there were other streams where a different sort of activity was appropriate. So we're going to be having those discussions with the probation service.
And do you learn from what activities proved to be successful? The reason I'm asking you that is I actually had a meeting last week with probation, and they were telling me about some of the supervised activity that was underway, had been underway, was the creation of the pathways up on the Divis and Black Mountain, and they were saying how successful it had been and how people were very enthusiastic about it. And then I just happened to be up there last Sunday for a walk myself, and it's brilliant and it's made such a difference. So, I mean, I think there's something to be learned from that. It's getting the right activity that will maybe just inspire people.
And I think there is a wider point there about the role of community sentences. Sometimes they can be presented in the media as a soft option. Now, that involved hard work for people, but it involved putting back something that now the whole community can benefit from, and it is very visible payback to the community. And certainly that is a theme that I know colleagues in the probation service are keen to return to.
Okay, thank you.
Thank you. Mr. Dixon.
Thank you, Chair. It's really just to follow on Ms McCarthy's comment about supervised activity orders. You also said that there would be certain circumstances when someone would go to prison and that there's the potential for less remission, therefore they're likely to be there for a longer period of time. But sitting in a warm, cosy prison cell, as opposed to perhaps sitting there and being taken out for 6 hours a day to create those paths. So is there an opportunity to mix supervised activity with actually being held in custody?
I know that more generally the prison service is interested in activities that are available to prisoners, and certainly there have been examples, I think particularly from McGilligan, where people have been going out into the community and getting on with work. We can certainly explore whether there are any potentials for this in terms of those who do end up in prison. I think up until now the reality has been some people have been in for 1 day, 2 days, 4 days. There's no potential in that sort of period. But certainly whether there was potential for those who had been fined very significant amounts and who were in for longer periods, it's something we can discuss.
Thank you. Thank you, Chair.
Okay, thank you. Any other members? Okay, well then, members, I'm assuming we're content for the consultation to go out, yes?
Agreed.
Agreed. Okay, thank you very much for coming to the committee.
Thank you, Chairman.
Members, we'll move on to the next item, which is the 6th monthly update on savings delivery plans. The relevant papers for members are pages 97 through to 204. So if officials want to come forward, that would be great. There's a range of issues that members may wish to cover during the evidence session, and these are set out in the clerk's memo, which you'll find at pages 97, 8 and 89. So let me welcome Glenn Capper, Deputy Director of Finance, Sir Rocks, and Louise Blair from the Financial Services Division within the Department of Justice. And as usual, this session will be recorded by Hansard and published in due course. So can I invite Glenn to the committee, and then we'll have some questions.
Good afternoon, and thank you for the opportunity to give you an update on the Department's finances. I plan to cover 2 separate areas in this briefing. Firstly, an update on our savings delivery plans as at the 30th of September 2013, and then a summary of our in-year position following the January monitoring round. Looking firstly at savings delivery plans. This is the Department's 6th monthly update, and following today's briefing we will publish our savings information on the Department's internet site. As the committee will be aware, savings targets for each spending area were factored into our Budget 2010 allocations. That is, budgets for each of the core directorates and our various agencies and arm's-length bodies were reduced by the savings amounts in each of the 4 Budget 2010 years. As your briefing note points out, the information provided has been prepared by each arm's-length body, and therefore it is their own and not the Department's interpretation of their progress against the savings plans. As at the end of September, net savings totalling £47.5 million have been delivered. We forecast delivering total net savings of £85 million by the end of March this year, against a total in-year savings target of £103 million. Whilst this would be reported as a shortfall of £18 million, it's important to note that this position takes into account the costs of the Prison Service Staff Exit Scheme. Because more officers are now due to leave than originally planned, we have incurred more costs this year, but will not see the financial benefits until future years when officers leave, impacting on this year's net position. Excluding the cost of the scheme, we would be on course to meet our gross savings target this year, and we now remain on track to deliver our total savings target of £109 million by March 2015. As you will see from the updates, some areas have indicated that there may be an impact on frontline services, and I thought it would be helpful to say something on the key areas. I've mentioned to the committee before that officials continue to work closely with the Probation Board to minimise the impact on frontline staffing. Over £1 million of additional funding was provided to the Board as part of its final budget settlement to reduce staffing impacts. A further £350,000 was allocated last year, and we've provided an additional £700,000 this year. In relation to the Police Ombudsman, their budget will require efficiencies to be made across the work of the office. However, the department also fully funded pressures totalling £5 million over the budget 2010 period. So in effect, their budget increases in cash terms. Again, we will continue to work with the Ombudsman's Office to fund as many of their future pressures as possible through the in-year monitoring process. Officials also liaise with all spending areas to ensure that savings plans remain on track and that savings targets are delivered. And we will continue to work with all of the various bodies across the department to look at ways to protect frontline services as much as possible. Turning then to our in-year funding position. This has been a challenging financial year for the department against the backdrop of a large legal aid pressure. The committee will know from previous updates that following the January monitoring round, we presented a bid to the Department of Finance and Personnel for just over £25 million. This bid was not met, but in his paper to the Executive, the Finance Minister stated his intention to monitor the financial position across all departments over the remaining months of the financial year to ensure the carry forward under the budget exchange scheme is maximised for the block and to ensure any unexpected funding surrendered by departments could be recirculated, including to the DOJ. Throughout this year, the department has taken a very proactive stance to manage its pressures. As a result, the position has improved since January monitoring through a combination of reduced pressures and additional savings. And it's worth noting that the January monitoring position was based on October's outturn, so we now have a much fuller picture of this year. So, for example, the total prison service pressure has fallen from £14 million at January to £9 million. Of this, £5 million is unavoidable, with the balance relating to the remaining officers due to leave under the exit scheme. A large element of the reduced pressure is due to lower costs of those who have left under the scheme. For example, some costs have been less than expected because of the age profile of officers and the choice by some officers to take a reduced lump sum and an increased pension. The legal aid pressure has also fallen by £4 million, and we will continue to monitor the position with the Legal Services Commission for the remainder of the year. The department has continued to press all areas for additional savings, and as a result, a further £3 million has been generated since January, mainly from compensation services and the Justice Delivery Directorate. During March, we will continue to press for further savings and reduce pressures as much as possible with a view to living within our allocated budget. However, we will also liaise closely with DFP with a view to securing additional funding, if it becomes available, to allow us to meet some pressures that would otherwise be unfunded. So I hope that provides you with an overview of both our savings delivery plans and our in-year financial position, and I'm happy to take any questions you have.
Thank you very much, Glenn. Just to be clear in my mind then with some of the figures, there was a legal aid pressure of 11.1 million in January in the monitoring round. Is that the bid? Was the bid for 11.1 million? Or was
the net bid to DFP, yes, was 11.1 million for legal aid. The Commission's pressure at that stage was actually 16 million, and we were able to use some internal savings that we had generated to offset it. So yes, the net pressure presented to DFP was 11.1.
So that has now fallen by a further 4 million?
That's fallen by a further 4, and we've been able to use some of the additional savings we've generated since January to offset that. So at the minute, we've written to the Commission and provided them with sufficient funding to take them through to the end of the year. with the caveat that if we get additional funding from DFP, we'd work with the Commission to see if they could use some additional funding.
So £7 million is still needed, but they can live within this? Is that what you're saying?
No, the funding that we have agreed, well, if I go back to the start of the year, we gave 15 million to the Commission as part of June monitoring. The position that they had at the end of January monitoring was 16 million of a pressure, of which 11.1 was the bid to DFP. Through a reduction in the legal aid pressure, through using some other savings from the department to put towards legal aid, the Commission are now in a position where they can fund their liabilities through to the end of this financial year. Now, that's not to say if we did provide some additional funding, they couldn't use it, which would actually be beneficial in taking some pressures out of next year. But at the minute, the Commission has enough funding to see it through to the end of March.
So is that, reading between the lines, you saying that they could pay out another 7 million, but they're going to let it roll over to the next financial year?
No, we're not even talking about a figure of 7 million. The Commission have indicated that if something in the region of 4 million or so, and maybe not even as much as that, became available, they may be in a position to use it this year. It's worth noting that the legal aid pressure is demand-led, so it's very hard to put an accurate forecast on the actual 12 months figure. So the way we have finalised the position with the Commission this year is that they have sufficient funding to go through to the end of March, and if, as I say, more funding did become available, perhaps somewhere up to £4 million or so, that they may be in a position to use that depending on their payment profiles and so on.
Okay. The £14 million to complete the prison service exit scheme, that's now reduced to 9 million is what the figure is to complete that work. And the reduction of the 5 million, is that just purely because there's been a calculation done that this is exactly, I think you indicated that £14 million in the prison service had reduced by 5 million?
Yeah, about £4 million of that 5 million reduction is due to the fact that at the start of the year when the prison service forecast their pressure, we're using notional figures or slightly dated figures. Whenever our officers actually come to leave, the prison service write to the DFP to get an up-to-date estimate or an accurate estimate of the cost of an individual officer. And due to time with officers moving into different age bands and so on, and as I said, some officers chose to take a reduced lump sum and an increased pension, which shifts some of the pressure from this year. That's reduced the pressure by a net 4 million or so.
Okay, so it's not, it's the pressure on that 9 million, which is now existing, that is still to allow the remaining 28, I think it is 27 or 28 to go. It's not that some have now left out of that last batch. It's just this is the more accurate figure as to how much it would cost.
Yeah, just to clarify the position around that 9 million and the 28 officers due to leave. You're right, there are 28 officers who have not yet received a letter to say they can leave because of funding. Of the 9 million pressure, about 3.7 or so of that 9 relates to the 28 officers. The rest of the 9 million pressure is other exit scheme costs, and by other exit scheme costs I mean the totality of the whole exit scheme, which includes the timing of when officers leave, the timing of when new recruits come in and so on. So some of the differences in those two profiles between the original plans have created the pressure as well. Okay. But it's roughly about 3.7 million relates to the 28 officers who are due to leave.
And that remaining amount then is part of the headway that the executive has agreed?
Yes.
Is there any indications that there will be something coming?
We remain hopeful. If we look back at last year, we got some additional funding from the executive, and that was in March. So these things tend to run quite close to the end of the financial year, simply because we're waiting for other departments to hopefully surrender some easements. But we remain hopeful, and as soon as we hear from DFP, obviously we'll be in touch immediately with the prison service.
Just to finish off my questions then, you touched on the long-term savings that this Invest to Save scheme will generate for the prison service. Is there a figure as to ultimately over the course of so many years that the prison service will be a net financial beneficiary of the changes?
Yeah, very roughly, if we assume there's 520 or so officers who will have left, assuming that the 28 go, I think that the savings purely from those officers leaving equate to about £26 million or so a year. Now, obviously, other staff have to come in to replace that gap, and there are other costs. But very roughly, I think prisons should be about £20 million or so better off as a result of the exit scheme. And the business case for the exit scheme included the payback period, so that it would demonstrate there was value for money in that scheme.
Right, thank you. Mr. Elliott?
Chair, thank you. And thanks very much for that. Can you give me some indication just how that 11 million of legal aid was so badly miscalculated? I know you did say, I think, Lynn, about, that it's very demand-led at a particular time, but I'm assuming, it couldn't be all related to that, or what percentage is that of the overall legal aid budget?
If we look at the big change in the legal aid forecast this year, as I said, in June, the forecast pressure after giving 15 million from the department was about £27 million. By January, that had come down to about £20 million. So there's a difference of about £7 million. And if your question is what's the reason for that difference, if we look at the early...
Sorry, just to explain that difference again. Where's that difference?
So at the if we go back to June monitoring, the Commission flagged the pressure must have been £42 million. And as a department, we allocated 15 to reduce the pressure to 27.
Yeah.
So that was a reduction in pressure simply because we gave extra funding.
Yeah. Okay.
So between that position and the declared January monitoring position from the Commission, the pressure reduced from 27 to 20. So to explain that difference of £7 million, we would have to go back to the start of the financial year. And at the start of the financial year, the Commission saw a big increase in the number of cases coming through, and also an increase in the average cost of that case. And obviously it's a demand-led business in many ways, so the Commission on a monthly basis has to work out, based on what it has on its desk, and also by looking at trends and so on, it has to try and calculate what the whole year's position is. So given that spike in the first 3 months of the year, the Commission extrapolated that out and forecast that the pressure for the whole year was going to be higher. By the time we got to October, they saw a bit of a dip in that early year spike. So when they ran that through the model, that pulled the pressure down by the amounts I talked about. So to give, I suppose, some credit to the Commission, it's demand-led. Cases are coming in at different volumes every month at different settlement amounts. So they're trying to use all that data to try and predict 12, 24 months ahead.
Okay. No, that's useful. If you don't get that 11 million, how are you going to make it up?
Well, as I've said, since that £11 million position, there's been an improvement in our overall financial
There's
position.
still a shortfall.
In terms of legal aid, the Commission have sufficient funding to get them through to the end of the year. As I said to the Chair, if a small amount of additional funding became available, we'll work with the Commission to see if they could use it. But at the minute, as a department, and having taken a decision not to do some things in other areas that we might otherwise want to do, there's enough funding to take the Commission through to the end of March.
Okay. What about the policing budget? Are there any pressures in it that we should see here?
No. Earlier in the year, the police flagged some pressures. The department's position in that was that the police budget is in effect ring-fenced within the department's budget, and the police have been able to absorb all of their pressures. So we were actually speaking to them this morning, and the police are predicting largely a break-even position for this year.
Okay. Thank you. Thanks.
Thank you. Mr. McGuinness?
Thank you very much. In some ways, my questions have been preempted. But if we go back to the prison officers and the reduction in staff, there's a considerable amount of saving there. When do you say that saving will come into effect?
I think that there will still be a pressure on the prison service budget in 2014-15, and some of that is the legacy of some of the exit scheme washing through the system, so the timing of officers leaving, the timing of new recruits coming in and so on. But by 2015-16, we should start to see the full impact of the savings.
Yeah.
Well, the savings are happening, but we should start to see the full impact of them.
Yes, yes, and in the same way, in respect of certainly criminal legal aid, there are savings from the amendment to the 2000 and or the 2011 settlement relation.
That's correct, yeah.
Now, I know the Minister has said, well, there are savings here, but you just don't see them now. When would you expect to see the savings come through?
In terms of legal aid?
Yeah, criminal legal aid, yeah.
Well, again, a bit like the position with the Prisons Exit Scheme, those savings are coming through the system. The time lag of legal aid cases means that it can take in some cases a number of years for a case to work its way through the system. So if there was a case in the system prior to the reform, it will be paid out at the previous rates. But all of the new cases since the introduction of the reforms are going through the system at the reduced rates, so those savings are happening. The calculation at the time was, I think it was either £18 or £20 million of savings would be delivered from that. Now, obviously that was based on a volume of cases at that point in time. So if the volume of cases goes up, some of that saving may be masked, albeit the saving is actually taking effect.
But although it's not apparent on these figures, there are savings being made at this moment
There
in
are.
time from
Yes, I think
2011.
Yes, I suppose what we could say is, were it not for the savings that have already been introduced, the pressure that we saw in legal aid this year would have been higher.
Much higher. Now, I understood to some extent the what you explained to Mr. Elliott, but you talked in terms of June, 27 million, and that was the pressure. It was actually 42, and then you gave the Commission, I think it's 15 million, so that reduced it to 27. So that was June, 27 million. And then you said you were down to 20 million, which was a reduction of 7 million. And then I look at the January monitoring outcome, and under that I notice 11.1 million legal aid pressure. Now, should that not really be a pressure of 20 million rather than 11.1 million? I know the chairs asked you about this as well.
Yeah, the position at January monitoring was the Commission declared a pressure of £20 million.
Yeah.
Through the January monitoring process, we had some other savings generated across the department.
Right.
And we used those to offset the £20 million to bring it down to the 11.1 that was the net position, if you like, declared to DFP.
Right.
And as I've said since then, we have given additional funding to the Commission, and that's brought them down to a level that they're able to make payments through to the end of March.
Right.
So the difference between the 20, I suppose to answer your question, the difference between the 20 and the 11.1 on your paper is because the department used other savings that it generated to offset some of the 20.
Yeah. Okay. I don't want to be going into the Legal Services Commission in any great detail, but the predictions that they make don't always seem to be correct. In fact, they seem to be quite inaccurate at times. And I know you explained some of the you gave some explanation for that insofar as the Commission saw a spike in cases and then anticipated that spike continuing. But is there not a better way of dealing with these anticipated increases or indeed decreases? It seems to me that it's almost day by day, week by week, rather than some sort of really considered space of time.
But I think your point about the robustness, or the historic robustness of the Commission's forecast is probably an accurate one, and that we have seen big fluctuations sometimes over short periods of time. I think the Department's response to that would be that, as a result of that, over the past few months, the Department has set up and is now leading a legal aid forecasting group, and that project that includes a number of areas across the Department that input to the legal aid model, plans to deliver a new legal aid forecasting model at the beginning of the next financial year, and the plan is that that should result in a much more accurate model that should remove some of those fluctuations.
Just to be certain about this, to understand this, the Department brought people in, or experts in, to assist the Commission deal with their...
Not necessarily brought experts in, but there are a number of areas across the Department that impact on the legal aid model. Courts, for example, is one where the volume of activity through courts ultimately hits legal aid. So the Department is leading a project that brings those various people together. It has also met with folks in Scotland and England to look at their legal aid forecasting models. So in terms of bringing in expertise, yes, it's done it that way. And that project is designed to deliver a much better legal aid model at the start of the next financial year.
Thank you very much. That's very helpful. Thank you, Chair.
Mr. McGlone?
Yeah, thanks very much, Chair. In relation to the Police Ombudsman's Office, they've already indicated the potential or the difficulties that could arise as a result of budget cutback in terms of frontline services. What provision have you made for that not to happen?
I couldn't ask you to put that question another way, could I? Just to make sure I understand it.
Two negatives there.
Absolutely not a problem. Police Ombudsman's Office, say, you're going to have less money, less able to provide frontline services. Therefore, what provision will the Department make to mitigate against that, or to make sure that doesn't happen?
Okay. To go back to the budget 2010 period, which began 2011-12, and covered 4 years, we asked the Commission, or the Ombudsman's Office, as we did all areas of the Department, to indicate their pressures and what potential savings they could make. And as a result of that, in setting the Ombudsman's budget for the 4-year period, they flagged a pressure of £5 million in relation to HET, and that pressure was fully met. So I suppose part one, I think, of the answer to your question is the Ombudsman's Office flagged a pressure, and the Department did fully meet that. And obviously, as with all areas of the Department, there's an in-year monitoring round process for the rest of this budget period, and if pressures are declared, the Department will consider the relative merits of those bids. I suppose I should say, actually, in year, I think the Ombudsman's Office actually declared an easement and handed back £200,000. And again, as we approach the next spending review for 2015-16, it'll be the same process where we will assess what the different areas of the Department need.
Just to get it completely clear in my mind, the budgetary requirements won't affect in any detrimental way the timeliness and quality of investigations or investigative process at the Police Ombudsman's Office.
I think what I can give assurance to is that over the 4-year budget period that we're now working in, the Ombudsman's budget was set on a basis that provided enough funding for their requirements, i.e. their pressure was fully met. If there are new pressures next year or in 2015-16, yes, we'll continue to work with the Ombudsman's Office to assess those pressures as we would with any bit of the Department. But as things stand, and looking at in year, all of the Ombudsman's Office requirements were met.
Right. So that's a yes then. In terms of giving an assurance that the timeliness and quality of investigative process at the Police Ombudsman's Office won't be adversely affected.
I suppose what I can say from a financial perspective is that the Ombudsman's Office bids over this 4-year period were met.
Okay.
They actually declared an easement this year, and if they declare pressures next year that relate to the sorts of things you've outlined,
Right.
that the department would of course consider those.
And thank you. With your permission, Chair, the probation service, they've highlighted that further pressures are anticipated in future years as a result of the 2-year investment from the department coming to an end, inability to sell properties and all that stuff. Again, their caseloads have increased beyond previous levels as experienced when the budget for 2011 to 2015 was agreed. So, can you provide a permanent funding solution to probation to make sure that again, likewise, frontline services aren't in any way diminished or reduced, especially given the pressures that they're under?
I think as context to all of those questions, we're obviously in an environment where budgets are reducing.
Yes.
I think that applies across all bits of the DOJ and all parts of the public sector. But in the context of that statement, again, if I look over the last 4 years, or the 4-year budget period when I'm working in, the probation board was one of the most protected bits of the department. Yes, it did, like all areas, have to make some cuts, but it was one of the most protected bits. We gave them an extra £1 million at the start of the 4-year period. We gave them an extra £700,000 this year. In terms of future years, the 2015-16 spending review period hasn't yet kicked off, but as part of that, I think that the department would again seek to protect areas like probation as much as it could.
Right, okay, thanks, Chair.
Right, thank you. Any other members? No? Okay. Can I thank you very much for coming to the committee? Appreciate it. Okay, members, the next item is proposed revision to the European Small Claims Procedure, Amendment of Regulation, EC. Pages 206 to 208, the Department has written regarding correspondence between the Minister and the Lord Chancellor on the UK's proposed opt-in to changes to the European Small Claims Procedure. The key change is to increase the upper limit for filing a claim under the European Small Claims Procedure from €2,000 to €10,000. The proposal also seeks to widen the definition of what constitutes a cross-border case, make more use of information technology, and have court fees limited to 10% of the value of the claim. The Lord Chancellor has written to the Minister of Justice indicating he believes that it is in the UK's interest to opt into the proposal, but is also aware that the proposed threshold for €10,000 is higher than the current Northern Ireland domestic small claims threshold limit of £3,000. He would welcome views on what level Northern Ireland could support as part of an overall UK position, and would like it to be at least £6,000, as this is the amount he believes is likely to be agreed by the Justice and Home Affairs Council. The Minister has indicated to the Lord Chancellor he is content to agree Northern Ireland's support for opting in, but his preference is for a more modest increase in the threshold limit, which is in line with the emerging views of other member states. Mr. Wells.
As one who very regularly uses small claims courts, because obviously as an MLA I can appear and the person doesn't have to pay any fees. I welcome the increase because it was 2,000, it's now 3,000. I still think that excludes an awful lot of smaller claims like dodgy cars or broken televisions or something, which are small claims, but if they exceed the limit, 6,000 strikes me as about right, though if it went to 10,000 I could well and truly live with it, because I don't see why a claim of that of £9,000 should be held in the High Court or the County Court. So I'd strongly welcome 6,000.
Well,
Okay.
leave the place up.
Okay. Happy for members to note it. Okay, next, the Department has provided an update paper outlining progress on the estate strategy. This issue initially arose in 2012 following a CGI report on the adequacy of courts' estate, which recommended that the Northern Ireland Court Service should develop a strategy by the end of 2012. The Department advised the committee the Minister had decided to consider CGI recommendations in a wider Department of Justice context, given the number of justice agencies, armed rights bodies and organisations with estate priorities, and the committee subsequently noted the draft principles underpinning the proposed estate strategy at our meeting on the 22nd of November 2012. Department of Justice Estate Strategy Programme Board, with representatives from the Northern Ireland Courts and Tribunal Service, Probation Board, the Youth Justice Agency and Prison Service, has been established and will ensure that the development of the strategy aligns with the recently published Northern Ireland Executive Asset Management Strategy. The work will be taken forward as 2 separate projects focusing on DOJ headquarters accommodation and DOJ service delivery accommodation. The services of a strategic investment board asset specialist have recently been secured, who is now the programme manager, and the SIB will also provide specialist asset management support as required during the duration of the programme. The Department will provide further updates over the course of 2014 as the estate strategy develops, so it's there for members to note, unless there's more information to be sought. All right, noted. Item 8, review of Code of Practice for appointment of independent members to the Police Board and Community Safety Partnerships. The next recruitment process for independent members is due to commence in early autumn 2014. The Department has provided a revised draft Code of Practice on the appointment of independent members for consideration for the committee. The Department intends to undertake a 12-week public consultation on the draft Code of Practice. When the committee considered the draft of the existing code in June 2011, concerns were raised regarding the handling of the principle of merit and in relation to the cost of the recruitment process, and particularly consultancy costs. In light of the committee's concerns at that time, the Policing Board considered whether merit could be considered at the final stage of the process, but concluded that it was not feasible, as the Board would not be compliant with statutory requirements within the Justice Act to achieve community representation. Change the word that was crafted in each of the partnerships. It was agreed, however, that the issue would be reconsidered in undertaking any revision of the code. The Department has reconsidered and the feasibility of the Policing Board taking merit into account, and the revised Code of Practice now includes an amendment to the process which allows the Policing Board to make the council scores available to the Board's panels in those circumstances where there are 2 or more candidates who are equally appointable on the basis of representation. A question has been included in the consultation document specifically aimed at seeking views on this issue. The Department has also indicated that no consultants are to be engaged for the next recruitment campaign. The Policing Board will manage the process in-house. So it's for members to note if they're content with the way this is being handled, or has any other comments to make. Otherwise, we'll note it. Noted. The Committee for OFM-DFM has written providing a template for each committee to document its EU priorities for 2014 and the work it's undertaken on EU issues during 2013. The committee agreed a response setting out its EU priorities for this year at the meeting last week. A draft response on EU activities and work undertaken by the committee during 2013 has now been prepared for consideration, and it's at pages 4 to 7 of the table pack. So if members are content with the draft response, then we can forward it to OFM-DFM committee. That. Correspondence, there's 9 items. I'll draw attention to some of them. Item 3 of page 302 in your meeting folders, correspondence from OFM-DFM providing a copy of the terms of reference for its inquiry into the Barossa Task Force and seeking any views on it by the 6th of April. So if members are content, we'll refer this correspondence now to the Department for comments around the terms of reference. And read. Item 8, an invite from the ACRO to their Justice Series seminar on children affected by parental imprisonment, and it's on Tuesday the 4th of March in room 115 if you want to go, Clark. Item 1 of the table packs correspondence from the Department regarding a stat rule it laid on the 7th of February this year to amend the explosives regulations. Following scrutiny by the examiner of statutory rules, the Department has had to make necessary technical amendments and provide a new rule. The new rule will be laid on the 28th of February and come into operation on the same date. The rule will come to the committee in the next couple of weeks for scrutiny as normal. Is there any other comments and correspondence? If not, we'll agree to action it as outlined in the meeting pack. Chairman's business. Following the meeting on the 13th of February, the committee wrote to the Minister seeking comments on issues raised in a letter from Randox regarding previous tender provision for drug testing within Northern Ireland prisons, which had been bundled as part of a wider tender with the Scottish Prison Service, with the result that it does not adequately address specific needs of prisons here. Members also agreed to have an informal meeting with Randox representatives. I, along with other members, held that meeting on Monday the 24th of February, and we discussed the nature of drug abuse in Northern Ireland prisons and the procurement process for the provision of drug testing. The discussion centred on the rationale for tendering jointly with the Scottish Prison Service and the impact this has on local firms and the process for any future tenders. So if members are content that we would ask the Minister to provide the justification for joint procurement with the Scottish Prison Service and tendering provision for drug testing within Northern Ireland prisons, and why the Prison Service is not tendering locally for drug testing when responding to the committee's initial letter. The DFP committee have also written in similar terms, so if members are content, we'll do that. Any other business? Queen?
Yep.
Mr. McGlone?
Chair, you already know about this. I don't know how the correspondence has found its way to you yet. I attended the all-party group of country sports on Tuesday, and it's quite clear that from some of the stakeholder organisations there are significant issues to be resolved around dealer licensing and firearms licensing and banding for particularly the holding of a firearms certificate. Which seems to have dithered and frazzled and wandered and meandered all around the place, despite the fact that it is a relatively simple exercise. So I don't know whether the correspondence has arrived with you yet in regard to that matter, but it is winging its way to you, so that the members have tried their best to work with the licensing authorities to try and elicit some modicum of progress from them, but it appears that the dialogue method isn't working, so it may well now be the good offices of this committee to ask just what progress is being made, or more to the point, why isn't progress been made?
Certainly I'm happy that whenever we get the letter that we should look into it. We've discussed it before, and I'm a member of that all-party group, and I think it was Mr. Kinahan mentioned to me earlier in the week as well that this was an issue that the group was likely to raise with this committee, so certainly on receipt of the correspondence we can decide how to take it forward, but certainly I'd be keen to have the officials back to the committee.
Thank you, Chair.
Okay. Any other business? Okay, our next meeting's 6th of March, 2 p.m. in this room.
Assembly, Committee Room 30.